Now let's just get down to the matter. In its response, the UN highlighted a number of issues in the criminal code law, such as inequality, privacy issues, freedom of religion, journalism, and sexual or gender minorities. So what is your opinion on this?
Well, okay, first of all, I would like to appreciate the efforts of Indonesian governments because finally we have our own versions of criminal code. The previous one that is the colonial Dutch rule version 1. So it is actually a huge achievement for Indonesia because it has been gone through a lot of period of time, a lot of process. So now we finally have our own criminal code. But still, I mean, this new penal code contains certain provisions that appear to be incompatible with the fundamental freedoms and human rights. And then to answer the questions whether it is okay for the UN to give the statement that there has been provisions that consider human rights. It is, I think, we have to be aware that human rights is now it's already become the concerns of the international community as a whole since a very long time ago after the World War II, and then international community successfully concluded the universal declaration addressing numbers of rights that has to be guaranteed at the international level. Human rights no longer becomes the domestic affairs of one state, hence state cannot justify its own treatment to these citizens, whatever they like. It cannot hide behind its sovereignty because there are certain rights that is guaranteed at the international level. And also this kind of rights that is controversial under this penal code, it also has been guaranteed in a more, legally binding convention or instruments that is international conventions on civil and political rights that Indonesia has been a party to this convention since 2005. So now we see that why this kind of allegations of the violation of human rights becomes also the concerns of international, since considered as a violation is the right that already guaranteed at the international level. Indonesia has become a party to the conventions that is ICCPR. So then we have to explain to the international community whether or not the violation is.
All right. So Diajeng, the UN is actually concerned that some articles in the revised criminal code are in conflict with Indonesia's international legal obligation in relations to human rights. So are you having the similar concern regarding our consistency with human rights?
Okay, so what I want to emphasize in the very beginning is that human rights is not absolute and human rights is not unconditional. So it needs to be restricted, it is true. Because without that kind of restrictions, human rights is not workable. It's not manageable. So, of course, there are some rights that cannot be exempted or cannot be deroged in any kind of situations, and we call it as non-derogable rights. But the majority of the human rights is that it can be restricted. So, as we see in our penal code or in our new criminal code, that are some restrictions to the specific rights, it is actually allowed under the human rights law. But then, according to that conventions that also guaranteed that kind of rights at the international level, that is ICCPR, the restriction itself shall be regulated in order for the state is not abusive when it restricts certain rights. So, for example, freedom of expression as one of the controversial issues in our new penal Code. This freedom of expression explicitly regulated under the ICCPR in Article 19. And it is true under this article, this kind of freedom of expressions can be restricted. But then there are some conditions that should be complied by the state in order for the restriction is still in line with the international standard. And it explicitly mentions in the wording of that article, if we see that, if we see in the articles that expression can be restricted for as long as it's provided by law and it is necessary. So provided by law means that that kind of restrictions or intervention of the certain of that rights by the state should be provided by the law, and it is provided under our penal code. So means Indonesia has passed the first step. But then what kind of law? So we have to see that the law itself should be clear and then accessible to everyone. So then it is arguable whether this specific provision that restrict the freedom of expression is clear, because there are some debate that the certain provision, for example, regarding the president insulting the state ideology, it is open to subjective interpretations. So if it's based on the subjective interpretation, means that it doesn't have, the which one is wrong, which is correct, because it is heavily rely on the subjective interpretations. So then the law itself, the quality of the law itself, it's also arguable whether it's clear or not. And secondly, according to that provisions, if we want to restrict the freedom of expression, it has to be to pursue the legitimate aim, and there are two legitimate aims. First, to respect the rights and reputations of others, or second, to protect the national security, public order, and public health. So then we have to see whether this kind of restriction, for example, in the state institutions, to pursue what legitimate aim? To pursue the rights and reputation of others, for example. So, for example, to pursue the institutions' reputations. So then we have to see whether this is the proportionate to restrict this kind of state institutions, and then we have also to see whether criticisms of legitimate aim, meaning that protect the rights and reputations of others, or in this case state institution, for example, it is also to restrict the people to the state of, because if we see in the international practice, this kind of legitimate aim is not for the state official to protect themselves from the criticisms.
All right, so Diajeng.
And then we open to further debate whether criticism and insulting is the same. So again, restriction is allowed or is permitted, but to prove to international level, or also to their own people, that this kind of restriction is necessary and proportionate. Otherwise, it is abuse.
Diajeng, our final question for this moment. We know that our new criminal code, particularly talking about human rights issues, actually adapted from the previous criminal code. So do you think is it still relevant for talking about the human rights regarding that this new code is adapted from the previous one?
Because we go back to the purpose of updating and modernizing our new criminal code is to adapt with our legal development to the science, to the democracy in Indonesia. But if we see the response of so many people with regard to the restrictions of these human rights, is in fact is not to support the democratic society in Indonesia, but then just to impair the functioning of the democratic society itself. Then we have to see whether the purpose of criminal code is achieved or not. Of course, we have to see in 3 years after it is fully implemented whether there is a sufficient safeguards for this kind of restrictions, and there are clearly the violations of the human rights of the people itself because of these restrictions.
All right.
And there has to be an access for the people to regulations if there's a violations. For example, like judicial review to the Constitutional Court.
Right.
And the access has to be works well. Otherwise, it is abusive.
Okay.
All right. Diajeng, Christianti, thank you so much for enlightening us in this matter, and thank you for joining us as well here, the Director of Human Rights Studies Center, Pajajaran University.